Court.
Again, everybody, thanks very much. Please be seated.
Thank you.
Thank you. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Ian Burnett versus Home Improvement Company of Vermont, case number 23AP344. Representing the appellant Ian Burnett is attorney Brendan Donahue. Representing the appellee, Home Improvement Company of Vermont, is attorney Oliver Abbott.
Thanks a lot. Good morning, counsel. We'll hear from counsel for the appellant. Please come on up. And if you would introduce yourself and identify your client for the record.
Sure. May it please the court, Brendan Donahue here, arguing on behalf of the appellant, Ian Burnett.
Thank you. Thanks very much.
The plain language of section 616A and the phrase all employment in the state necessarily implicate Vermont business paying its employees to perform services in and outside the state of Vermont. The term employment necessarily includes both an employee and an employer. And the core of that definitional relationship is the exchange of money for services between the two. Straightforwardly, the employer in this case is a Vermont employer. It is a corporate citizen of the state of Vermont. It has business operations in the state of Vermont. It has property in the state of Vermont.
It's incorporated in both New Hampshire and Vermont?
It's only incorporated in Vermont.
Okay.
But it has its principal place of business. It's clear now in New Hampshire.
Yeah.
And that's the root of the conflict.
I haven't seen any statute, rule, or case that discusses or makes relevant the issue of where a business is incorporated for these purposes of what we're dealing with here. So where does the authority for that position of yours come from?
From two places, Justice Carroll. One is the plain language itself. I think it's the starting point, at least as I understand it, for the analysis. And so and the use of the word employment in other places in the state of Vermont refers to Vermont employers for purposes of unemployment compensation in other places. So that's one place for it. And the other is just national case law that says when you have a corporation, it's a citizen in both places. Where
So taking an example of Delaware, which is a very strong culture of having corporations be incorporated there. So any company that's incorporated in Delaware would be subject to workers' compensation injuries from wherever they occur in the country?
Under my argument, yes. But again, I don't think there's anything untoward with having a state that has a place of citizenship in a particular jurisdiction being held account to those laws. But in this case, it's not as severe as that. The court's concerned. It's not just a piece of paper saying a place with a corporation. Vermont Home or Jansowitz, or whatever the court would like to call it, was incorporated here and had its principal place of business here in Vermont and Bellows Falls for years. And just so happened to move its business operations across the river. But it still owns vehicles registered with the state of Vermont, or at least it did at the time of this injury. It had operations at its old location. I would use it for waste. And it advertised it. Today I have a yellow flyer I got last night from Jansowitz asking for my business here in Springfield, Vermont, where I live. So that is my argument. But if the court's concerned about it, it needn't be that extreme because the facts in this case show much more than just a casual.
But what you're asking us for is a rule that says that as long as a business is incorporated in this state, that all the workers' comp claims against it will be adjudicated here. Isn't that what you're arguing? Isn't that the extent of it?
That is part of what I'm saying. That is my first argument. My second argument would be on the facts of this case. All right. So but that is my argument because Vermont employment necessarily includes two entities. Right? It's not just where the services are performed, it's where the employer is. And it doesn't make any sense to have a Vermont employer on paper and in practice lose its status as a Vermont employer based on the place of injury. I don't think that's how we treat corporations in the state in other contexts. I don't understand why we.
Well, the statute is painted with a pretty broad brush, and it's very difficult to find any cases. But one of the things I did find was looking at this from sort of a conflicts of law principles. In other words, where does it make sense as a matter of public policy to have this workers' comp case adjudicated? And looking at the various factors, you've got a claimant who lives in New Hampshire, was injured in New Hampshire, and works for a business with a principal place of business in New Hampshire. Doesn't New Hampshire have the most interest really for adjudicating that than Vermont? Why would we bring it over to Vermont?
Well, it's a good question, Justice Johnson, but I don't think that Vermont has just a casual interest. This corporation chose to be incorporated here and didn't change its domicile, even when it moved its principal place of business across the river.
But why should that be the overriding factor when you've got all these other factors that sort of bear on the case?
Well, there are other factors other than just the place of incorporation. It continues to use its old principal place of business for business operations. It stores materials there. My client's been there 3 times during the course of this case since his injury to work at the old job site, however briefly. Vehicles are registered with the state of Vermont. There's lots of overlapping connections. However, in a case like this where it's an accepted injury, there really isn't a conflict between the 2 jurisdictions. So principles of comity and forum nonconvenience don't really apply. And the Department of Labor hasn't shown a concern with that. In the Hilliker case, it was more or less the same. You had a Massachusetts employer, you had a Vermont resident that was hired here, but did all the work in Massachusetts and was heard in Massachusetts. And the Department of Labor said it really wasn't an issue because all you're doing here in the state of Vermont is giving the additional benefits under Vermont law. The state isn't disrespecting what Massachusetts is doing, it's undoing its ruling and accepted claim. It's just saying you are entitled to additional benefits.
But didn't you just distinguish Hilliker by saying that the plaintiff or the appellant or whoever's seeking the workers' comp award was somebody who was hired in Vermont and both a resident of Vermont? That's easily distinguishable from your case where there is no injury in Vermont. There is, he wasn't hired in Vermont.
So those facts are different, Justice Waples.
Yeah.
But I was trying to answer Justice Johnson's question, and I'll get back to him in a second.
Oh, sure. I'm sorry.
As to why the state of Vermont should have an interest in the case. And I'm saying in other contexts where the same factors apply, there's even less of a connection to Vermont. Vermont has shown that it has a compelling interest in making sure that its citizens, in that case, or injured workers in mind, have access to the full panoply of benefits that are available here in Vermont. Sometimes they're greater than they are in this case. But in the case that you're talking about, that was a Section 619 case, which is for injuries that occur outside the state.
Right.
And in the hook there is the hiring. But there's a hole in the statutory scheme that doesn't make a great deal of sense, where if you have an employee that works in the state of Vermont or works for a Vermont employer, but happen to be hired across the river, there's no jurisdiction for an out-of-state injury. So the act of hiring is determinative. But if you actually work for a Vermont employer, you're out of luck. That doesn't make a great deal of sense, and I don't think that's what the legislature was after here. And it clearly knew the difference between the word employment and the word hire or injury when we look at the statutes. So my argument before the court is that the legislature knew what it was doing when it used that word, and that word applies here.
Would your argument require us to overturn the Martin Furman lumber case? And if not, why not?
So Justice Carroll, I don't think that it would, because that case actually I think supports my argument. That the dictum in that case was quoted by the Flores-Diaz Department of Labor decision, and then this decision below here. But that case considered a minimum number of employee requirement under 616A before it was amended. And so the argument there was because the Vermont employee that died on the job while working for a Massachusetts employer was the only employee in the state of Vermont. They didn't qualify for that minimum statutory requirement. Okay? So what this court did is it said it's wrong because the legislature didn't include it, to include a geographical restriction on how one counted the employees. So the Massachusetts employees counted just as much as the single solitary Vermont employee, and therefore the statute applied. I don't think it requires overturning that case. I think that case actually supports this case because the legislature similarly here didn't include a geographical restriction of the place of injury. That was read into the statute by the commissioner, in part by looking at the dictum of the Martin case, which wasn't talking about the statute. It was talking about the contractual relationship between the parties. And back then under 612 or 613, employers could exempt themselves out of the act by specifying and taking certain steps. And that wasn't done there. And that case was quoting the Gregg, which was really an election benefits case. It wasn't actually considering that primary issue. So as oftentimes happens when courts are deciding cases, things that are similar but not on point get taken and imported and carried along. But there isn't actually an inconsistency between the ruling in that case and what I'm seeking here.
Okay. I'm sorry, so I'm a little confused. Are you arguing that in the Martin case, the injury wasn't sustained in this jurisdiction?
No, I'm not. What I'm saying is that the argument was that because employers were exempt that had less than 2 employees, and the argument there was the Massachusetts employer was exempt because the only employee that should count except the defense was the single solitary employee in Vermont that was injured. And so what the court did is said, no, all the employees count because the legislature didn't say only employees physically located in the state of Vermont.
I thought that case, though, really focused on the fact that it's not the head count of employees that really matters. It's where the injury occurred.
That's not the way I read it. I read that case to be focused on the plain language of the statute. And the section that's quoted by Flores-Diaz really had to do with section 612 and 613. At least that's the way that I understood it. And obviously, this court knows better than I do. But it had to do with the contractual relationship. And it talked about the contract doesn't become subject to jurisdiction in the state until services are performed within the state. And that's what invokes 612 or 613. But again, even then, I don't think that there would be a lack of permanence. I don't think that once services are performed for a Vermont employer, that it vanishes the second you cross the river. I don't think that's what the court was at in that particular case. I'm going to reserve my time unless the court has more questions. Thank you.
All right, thanks. We'll hear from the appellee, please. Come on up. And for the record, introduce yourself and your client.
Good morning, Your Honors. You may please the court. I'm Oliver Abbott, and I represent the Appellee Home Improvement Company of Vermont, better known as Jankowitz & Son.
Thank you.
We're here because the appellant claims the Commissioner of the Department of Law erred in holding Vermont to not have jurisdiction over his workers' comp claim. But this is based on claimant's novel interpretation, as we've already discussed, of 616. This interpretation is flawed, however. Nowhere in the statute does it speak to the place of incorporation as controlling where jurisdiction attaches. If the legislature wanted to make that the case, it could have easily done so, but it didn't. Similarly, claimant's arguments about the employer's ties to Vermont, they maintain these ties can somehow provide subject matter jurisdiction, but these ties, I think, speak more fairly to personal jurisdiction, that the employer owns real property in Vermont, advertises in Vermont, does business in Vermont. These are all factors the court would consider whether it could comport with notions of due process to hail that employer into court. But again, if the legislature intended for subject matter jurisdiction to attach where it could exercise, where a court could exercise personal jurisdiction, it would have so stated, but it didn't here.
So the clarity issue is that subject matter jurisdiction does not exist solely because the event occurred out of state.
I'm sorry, could you run that?
That the injury occurred. He's working for a Vermont corporation. They have an office in New Hampshire or a place in New Hampshire. And then the injury occurred in New Hampshire. The clarity argument would be that there's no subject matter jurisdiction in Vermont because the injury occurred in New Hampshire.
Correct, under the standing interpretation of 616.
Thank you.
The factors listed by claimant, again, might establish personal jurisdiction, but not subject matter jurisdiction absent the injury in Vermont. Second, I think even if we accepted claimant's interpretation of 616 in part, not putting aside the incorporation issue, it's not necessarily accurate to say that Jankowitz is a Vermont employer. Its sole business operations is based in New Hampshire. That's where the claimant reported to for work each day. He was paid in New Hampshire. He was hired in New Hampshire. They do, as claimant's counsel pointed out.
They're doing business here. I mean, you can't walk away from that. They're doing business here.
Sure, Your Honor. But again, I don't think it's fair to call it a Vermont employer over a New Hampshire employer. It pays its employees in New Hampshire. It hires its employees in New Hampshire, at least in the case of the claimant. That's where the workers report to each day, even if they might have a project to do in Vermont. They first go to the Walpole chief business location. I think if we're looking at whether to call it Vermont employer or New Hampshire employer, it's a New Hampshire employer. But third, and again, even if we accepted that the claimant's interpretation of 616 was reasonable, the problem is it's just an alternative interpretation of 616. We still have the commissioner's interpretation of 616. And absent some indication of compelling error, that interpretation is entitled to deference. And we would submit that the claimant has not shown any indication of compelling error. He's just proposed an alternative. The commissioner's definition or interpretation is it's based on the Martin v. Furman opinion, Flores, the commissioner's own plain meaning analysis, as well as viewing the rest of the Workers' Compensation Act in concert, the basic premise that you need an injury in order for workers' compensation to apply. That injury is pivotal, it's a focal point, and then coupled the need for an injury with 616 reference to employment in the state, the commissioner has synthesized an interpretation of 616 that applies this baseline jurisdiction for workers' comp, where you have an employee injured in Vermont while working for an employer. But the key fact is the employee must be injured in Vermont. This is the bedrock of our workers' comp statute.
The Vermont insurer denied the coverage, didn't it?
Yes.
And so how would the defendant, how would the appellant here even recover in Vermont if the insurer's denying the claim?
My understanding is the claimant seeks, based on the Hilliker decision, seeks dual administration of the claims.
Oh, that, okay.
New Hampshire has accepted, the New Hampshire coverage carrier has accepted the claim, and the claimant has received New Hampshire benefits. And I believe the claimant would like to supplement those benefits to the extent New Hampshire provides, or Vermont provides excess benefits. For Hilliker, though, I believe the Vermont insurer would get a credit based on what they've paid in New Hampshire. But again, I think, as you discussed earlier, Hilliker is a far different case where jurisdiction, where you had, sorry, I'm blanking on it. He was hired in Vermont, so there's clear jurisdiction under the other statutes that speak to jurisdiction when the worker is injured outside of the state.
And that really goes back to your argument, doesn't it, Mr. Abbott, that if you read 616 and 619 in perimeteri, that it really is the location that matters. Because under 616, jurisdiction is conferred if the injury occurs in Vermont, but then 619 refers to injuries outside of Vermont, but hired in Vermont.
Correct.
Okay, thank you.
Yeah, I would say 616 is the foundation, and then you have these subsequent statutes that provide exceptions where the injury occurs outside.
Okay. That all go back to location.
Correct.
Okay, thank you.
And then finally, even if the commissioner erred in holding it didn't have jurisdiction. We would submit this was harmless error because under principles of comity and related concerns, New Hampshire really is the proper forum here, and that the department should decline to exercise jurisdiction in any event. Under Larson's London Workers' Comp treatise, there are 5 facts that will give rise to a legitimate interest that the state would have in applying its laws to a workers' comp injury. And they're the making of the contract, the injury, the existence of the employment relationship, the residence of the employee, and the location of employer's business. We probably would submit here all 5 factors favor New Hampshire, and Vermont in this case has nothing more than a casual interest in seeing its laws applied to this injury. And then in conclusion, I think as the commissioner below put it, this is essentially a New Hampshire case, Your Honors, and submit the department did not err, declining to exercise jurisdiction.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 2 minutes and 51 seconds.
Counsel.
Thank you. I'll try to keep it brief. My closing remarks, I would say that if you have dual citizenship, there's nothing wrong with dual administration of a claim. And that's what we have here. This entity is clearly got a foot in both states. It's clearly a citizen of both states under federal law books and corporations. Having dual administration is certainly not unfair. And in fact, it happens all the time already in the state. Many times, at any given time, I have one case in my office that has this overlapping issue. It's just not always one that's contested. So, and again, back to the comment about New Hampshire has more of an interest than Vermont does. I disagree for all the factors that we talked about and the overlapping connections this employer has in doing business here. But the connections here are even stronger than they are in other contexts than they were in the Hilliker case. And the last thing I want to point out is that it is a bit dangerous to read the statute the way the FLE suggests. One, the plain language doesn't say that. There's nothing in there about place of injury. That has been added to the statute. It wasn't added by the legislature. But if that interpretation is applied, you're going to see, and they would be remiss in not doing so, you're going to see those employers that have dangerous activities here in Vermont, have them perform them across the river and hire them initially across the river, because that is an end run around the statute. I don't believe that's what the legislature intended, and it's certainly not fair. And the humane purposes of the act for purposes of statutory construction under the Kapusta versus Department of Health and Sear versus McDonald, even though I know Justice Reiber, you got a dissent in that case, clearly say that in the absence of evidence to the contrary, we find in favor of benefits. Here, the plain language requires it, and if it's a tie, the statutory rules of construction would suggest that this court should find in favor of Mr. Burnett.
Okay, thank you very much. Please call a conclusion of the hearing.
The next hearing for the